My name is Sharkey. I'm a partner in the firm's property and probate department, and I'm here today to talk to you about what items you should consider when making your will. Not everybody is familiar with the will drafting process, or what matters they should consider before going to see their solicitor. The legal terminology used can often be confusing, and many are not familiar with the legal restrictions that exist in disposing of one's estate. I therefore thought it would be useful to explain the issues one should consider before instructing us to draft their will. The first item you need to look at is what do you actually own, and secondly, what debts you may owe. It is useful to write down a list of your assets in one column, for example, and your debts in a second column. This will give you a picture of what you will be able to dispose of under your will. You then need to consider whom you want to benefit under your will. It is again useful to put the names of the intended beneficiaries in writing and to consider what assets you want to pass to those beneficiaries. In considering this aspect, one should bear in mind the Succession Act 1965, as it imposes certain restrictions on what you can do with your estate. Some of these restrictions are as follows. There is the legal right share. If you are married with children, then your spouse has a legal entitlement to 1/3 of your estate upon your death and to 1/2 of your estate where there are no children. You therefore need to factor this into any proposed distribution. If you're married, then your spouse also has a right to acquire the family home in part or full satisfaction of their legal right share. As matters currently stand, the Succession Act 1965 provides that a child can bring an action against a deceased person's estate when they believe that parent has failed in their moral duty in providing for that child. This arises, for example, where a child feels hard done by under the parent's will. You also need to determine whether or not the assets are in your sole name or whether they're held with another person. In many instances where the assets are held jointly with another person, then the principle of survivorship applies. This means that the asset will automatically vest in the surviving owner upon your death. Assets of this nature cannot pass under your will. You now need to consider whom you want to act as executor. The executor is the person that you entrust to carry out your instructions set out in your will. Generally, I'd advise that you have a minimum of 2 executors. If you name only one executor and that person dies, then it can complicate matters. It is also advisable to speak to your executors beforehand and get their agreement to act. In some cases, executors who did not know they had been in fact appointed have refused to act, leaving the will without an executor. If you have minor children, then it is advisable to appoint guardians under your will. The guardians would act in the event that both parents are deceased. For this reason, you want to appoint people who have a good relationship with your children. If appointing more than one guardian under your will, then it is advisable that such persons should reside together. You further need to determine whether or not a discretionary trust should be put in place. If you have minor children, then it is prudent to create a trust whereby you appoint certain people to hold those assets until your children reach a certain age. The person you would appoint to do this is known as the trustee, and they should be people in whom you have the utmost trust. The type of trust used in this scenario is often a discretionary trust, as it allows your trustees to apply money from the trust for the benefit of your children. Ultimately, you will say that when your youngest child reaches a certain age, then the trustees must distribute the assets amongst all your children in a specified shareholding. Depending on the extent of your estate, the tax liabilities of the beneficiaries can be quite punitive. There are certain estate planning measures which can be taken to reduce this and upon which we can advise you. It will certainly help you and the solicitor drafting your will if consideration is given to the above topics before your first meeting. One point of advice is that the will should not be overly complicated and that the language used should be plain and straightforward. This certainly helps towards avoiding any disputes in the future. As I mentioned, I look after the firm's will drafting, and I'd be delighted to assist you with any queries you may have. Thank you.